Judgment in the appeal, N and ACCG and others.
MN is a young man in his 20s who is profoundly disabled, both physically and mentally. Among other things, he has frequent epileptic seizures, so that he needs a nurse to be on hand at all times to administer emergency drugs. He has the cognitive ability of a child under the age of 1 and needs help with all aspects of day-to-day living. He needs to have his carers nearby at all times throughout the day and the night. He comes from a large, close and loving family, and 2 of his brothers are also severely disabled. His parents were unable to cooperate with the children's services in meeting his needs, and so a care order was made when he was 8 years old. But his parents have always wanted to have him back to live with them. The care order was due to expire when he reached 18, so the local authority applied to the Court of Protection under the Mental Capacity Act 2005 to ensure that he lived in a suitable adult care home and his contact with his family was properly regulated. Responsibility for his care passed to the National Health Service when he turned 18, and so the local clinical commissioning group now takes the lead in these proceedings. Originally, the parents opposed his move to the adult care home where he now lives, but they now accept that this provides him with a safe and settled home and that he should stay there for the time being. The home has also agreed to allow his parents to see him whenever they want during the day, in accordance with their normal visiting rules, which are that they give the home 1 hour's notice of their intention to visit. The dispute, therefore, has narrowed to, first, whether he should be allowed to visit his parents in their home, and second, whether his mother should be allowed to help with his intimate care while visiting him in the care home. The problem is that the care home is not able to provide the staff to enable him to visit and considers it too risky to allow his mother to help. The clinical commissioning group is not prepared to fund the additional trained carers who would be required to do what the parents want. The case was listed for a 3-day hearing where these issues could be explored. But the night before the hearing, the local authority told the parties that they were going to argue that the hearing should not go ahead. There was no point in doing so, because if the clinical commissioning group was not prepared to fund what the parents wanted, the court could not order them to do so. The judge accepted this argument and made the order sought by the authorities. The Court of Appeal upheld her decision. Not surprisingly, the parents feel a burning sense of injustice that matters turned out as they did. The issue before this court is the role of the Court of Protection in a dispute of this kind. The Court of Protection is there to take decisions on behalf of a person who, because of mental disability, is unable to take the decision for himself. Nobody disputes that MN is unable to decide for himself whether to visit his parents' home and whether to have his mother take part in his intimate care when she visits him. The court which makes the decision for him has to decide what will be in his best interests, taking into account his own wishes and feelings, his likes and dislikes. But it is axiomatic that the court can only take a decision which he himself could have taken if he were able. As the judge explained, if MN had the mental capacity to decide, but had the same physical disabilities and care needs, and the care home were unable or unwilling to facilitate visits to his parents or his mother helping with his care, he would have 3 choices: to accept the conditions of residence in the home, to fund alternative care elsewhere if he could, or to try and negotiate a change in their attitude or a move to another publicly funded home. In essence, those are also the choices facing the court. The court cannot order the clinical commissioning group to fund extra carers. The court cannot order a care home to look after a resident in any particular way. The court has therefore to choose between the options that are available to it, in just the same way as a person with capacity would have to choose between the available options. If a public authority makes an unlawful decision, then this can be challenged in the administrative court. But the law governing the provision of public services, which the authority have to operate, is different from the law governing the decisions which the court has to make. And the Court of Protection should not be used as a way of putting pressure on the authorities to make a decision which they would not otherwise have made. This means that the court, in the exercise of its case management powers, is entitled to conclude that a full hearing of the competing cases will serve no useful purpose. It does not mean that a service provider can preempt the court's proceedings by refusing to contemplate any change in the care plan. Developments frequently take place during the course of the proceedings, as happened in this case. It is for the court, not the parties, to decide whether any useful purpose will be served by holding the hearing. It follows that the judge was entitled to decide as she did, and that this appeal must be dismissed. The court will now adjourn.